Okay, so continuing on with my series of videos from the hearing on January 23rd, I am now moving on to the Frank's motion portion. And this is a long one because Anne is going through all of her points of where she thinks a Frank's hearing should be granted. So there's a lot to unpack in this one. So let's get started.
All right. Your Honor, the purpose we're here for today is to offer you a preliminary showing of why we should have a Frank's hearing. To do that, we will show you that in this circumstance, the affidavits that supported search warrants in this case had false information in them that was intentionally placed there. There was intentional omissions of information that are material and exculpatory to Mr. Kohberger, and without the false statements and with the added information in, probable cause on the warrants should not be found. Today, I'm asking you to listen to what we have to say, look at the exhibits that have been admitted, and I'll walk through those with you to talk about the 13 areas. And at the end of this hearing, we will have met the preliminary showing required in order to schedule a Frank's hearing and fully challenge this.
With the exception of the IGG, which I think we've already heard the evidence on, so.
We did hear the evidence, Your Honor, and I will not repeat that evidence. I'll argue from that today.
My only point being that's not in the preliminary stage that all the other issues are on.
Okay.
So Anne is saying that she believes there are 13 parts of the affidavits for warrants that were either intentional omissions of exculpatory information or intentional false statements that were put in order to get probable cause. So she's making some very, very strong accusations in trying to get the judge convinced that there should be a Frank's hearing.
Your Honor, in this case, there were a lot of search warrants. I'm going to draw the court's attention to those beginning on December 23rd. That day is important because it was just a few days prior to that for the first time ever, Brian Kohberger's name came up in the course of this investigation. Your Honor wouldn't know that by reading the affidavits for probable cause. Nobody would know that. That's because that information is omitted from the affidavit. That information is something that you heard about this morning in testimony, that but for the FBI's work going into databases they shouldn't have been going into, violating their own policy, keeping no records, and doing this all behind the scenes in secret, that's the only way a name was produced. Prior to that time, the lead detective in the case had not heard the name Brian Kohberger. He had not crossed their radar. That's nowhere in the affidavit, and that's important because that's intentionally withheld from the affidavit because of the work the FBI did, because the FBI went behind the scenes and did things that they shouldn't have been doing, because they searched databases that they shouldn't have been doing. We don't know what else they did wrong because everything else is a secret. We don't know what else they did wrong because there's no record kept. There's no process kept. We can't rebuild the process that they did to identify Mr. Kohberger. We can't do any of that because they kept no records, produced no records, and did this all behind closed doors, and it was withheld from the magistrate. Had the judge heard about that, signing probable cause, that would have been really important to understand. We don't know this name. We heard it for the first time now, and we only know it because we violated our own policy to find that.
So here she goes again, trying to act like DOJ policy is somehow a law. So one of the omissions she believes that law enforcement made in the affidavits was the IGG. So she thinks that the IGG should have been included and that Megan Marshall, the magistrate, should have been told when signing off on search warrants. But again, there's no violation of law if they went outside DOJ policy. So that doesn't make sense that that would be the reason why they wouldn't include it in the probable cause affidavits. So let's continue.
That may have given the judge caution. It may have made the judge wonder what else are they doing behind the scenes. But that was withheld from the judge. That judge never got to know that. Let's talk about what the judge did get to know with that in mind, and that's a really important backdrop. These affidavits are a group effort. I think the court's heard a little bit about that, and if the court has some of the initial exhibits, the court will know that this was a group effort. The FBI, the same FBI that went behind and violated their own policy to try to identify somebody, they were co-located with Moscow Police Department and working on these affidavits to present to the judge.
Okay, so now she's bringing up the fact that the affidavits were basically built on as they received new information, and different law enforcement officers and even the FBI were involved in gathering that information. So the probable cause affidavits included information gathered by more than one person. So if Mowry signed off on one or Brett Payne signed off on one, it could have contained information from several different officers, including agents from the FBI.
The first warrant that gets anything related to Mr. Kohberger is, I refer to it as AT&T 1. It's on 12/23/22, and it's for 48 hours worth of records of Mr. Kohberger. And I want to go through that warrant with the court having in mind that the IGG was purposefully and intentionally withheld from the magistrate. And I want to talk about some of the other problems with that warrant. This probable cause affidavit talks about.
Okay, this is where she starts talking about Dylan and her statements to law enforcement versus what was in the probable cause affidavits.
An interview they had where the person that was interviewed said that she heard things and saw things within her house. But what is written in the probable cause affidavit is seriously lacking in detail. It's wrong and it's false in many places. The way the affidavit reads, it says, this person stated she went to sleep on the second floor. She was awoken at 4 by what she stated sounded like one of the victims playing with the dog, which was on the 3rd floor. A short time later, she thought she heard one of the victims say something. That caveat, she thought she heard, is a problem. That's not at all what was said.
Well, if you look at the probable cause affidavit for arrest, it says that she heard what she thought was Kaylee saying there's someone here. So I'm not quite sure where that issue is, because it says right in there she thought. So it feels like they're basically saying that's not for sure that she heard that, but maybe I'm misinterpreting that. Let's continue.
This person was interviewed shortly after 911 was called in the afternoon of November 13th, 2022.
Okay. Did you hear that? Even the defense is admitting that Dylan was interviewed that afternoon. So can all the conspiracy theorists please stop saying that law enforcement never even interviewed her until days later? Obviously, she was interviewed that same day, and Anne just confirmed it.
And she was sure. I'm at Defendant's Exhibit 8A, page 281, lines 4 through 10, when this witness was sure that she heard this particular victim go up the stairs, and then come running back down the stairs. That is not what's contained in this affidavit at all.
Okay, so that was new information we hadn't heard before. So Dylan thought she heard one of the victims go down the stairs, then back up the stairs. So Anne is saying that that should have been included in the probable cause affidavit, but I am failing to see how that would be exculpatory to Kohberger. All to me that would do is just further that somebody was in the house attacking these victims. But let's continue.
That is repeated during this same interview a couple of different times at page 287. It's also repeated in a subsequent interview that same day. This is Defendant's Exhibit 8B. That's at page 313 and again at 320. It's repeated again in D8C as well. That is important because that's misleading to the judge. That waters down what was said, and that matters in the probable cause affidavit because the officers, when they wrote this, knew that wasn't the case. They knew this particular person that DM said was upright and running down the stairs, that's not what happened. That person was killed in the bed and never left the bed.
Okay, interesting. So Anne is saying that the person that Dylan believes she saw running up and down the stairs actually never ran up and down the stairs. They were killed in their bed and never left their bed. So one has to assume that's either Maddie or Kaylee that she was talking about. But again, how is that exculpatory to Kohberger? I mean, I guess it could make you question what she really heard and saw. But at the end of the day, there was still somebody that went in the house and killed 4 people.
And so the officers water that down because they know that fact is wrong, but they don't tell the magistrate that. They also don't tell the magistrate that this witness has claimed memory problems, that this witness has claimed that she's not sure what she heard or saw was real or whether it was at a dream, and that is contained in Defendant's 8C, and that's going to be beginning at page 396, 398, 399, 403. There's further statements from that witness in that police interview that said that she had had too much to drink and couldn't remember. None of that is given to the magistrate. That is information that's withheld. That's credibility of the person telling law enforcement these things, and the magistrate had a right to know that whatever is laid out in here isn't exactly the way it was. That person had credibility issues, and she said things that were just absolutely untrue and couldn't have been true. Law enforcement knew that. That was intentionally withheld from the magistrate. That matters when we're talking about credibility and sets this whole thing into motion.
So that confirms what I had long suspected, was that Dylan wasn't sure if what she was seeing or hearing was real or a dream. And that has happened with many people that have survived crimes like home invasions. You can look up Alana Zabel, whose roommate was beaten almost to death, and the perpetrator walked into Alana's room and she thought she was dreaming. She didn't even realize until the morning what had happened. And Alana herself has reached out to Dylan. So that's why I was believing from way back that Dylan had no reason to know that anybody was really being killed. That yes, she did see and hear things, but it didn't register with her. And I don't see how putting that into the probable cause affidavit would change anything about probable cause. I mean, yes, I guess you could say it makes her uncredible as an eyewitness, but it still leads credibility to the time it happened and that somebody was in the house, whether she thought it was a dream or not. It said she was texting with Bethany, so obviously that would lend to the time frame. So there is some credibility there, but I just don't see how putting that in there would have changed Megan Marshall's mind about search warrants for the possible suspect, because I don't see how that would change who the suspect was.
Your Honor, the next part of the affidavit talks about what they have determined to be suspect vehicle number 1. And it trails a path of pieced together cameras. But what they don't tell the magistrate is that the camera near the residence, the 1112 King Road camera near 1122 King Road, you can't tell what kind of car it is. They don't tell the magistrate that that's an impossible car, that their expert can't make an identification off that. They don't tell the magistrate that this is pieced together from various other videos throughout the area. That's withheld from the magistrate. That's important information when you tell a magistrate, we found this car doing this thing and we know what it is that's around this particular area.
I'm just going to say it. So what if it's pieced together? If you have several cameras in the area that the car is caught on, and you know what timestamps each of those are, you put it together. It's like a puzzle that you put together. Obviously, you will never have fluid video of somebody going from point A to point B when you're talking about driving through neighborhoods. It's just going to be from various people's Ring cameras or various cameras on stores, etc. So, of course, it's pieced together. I mean, you obviously would not think Megan Marshall would think that them telling her that they've got the car on video meant that they had him on a continuous loop. I don't think Megan Marshall is stupid. So, again, how would this be exculpatory? How would this change her mind on probable cause? And if the car couldn't be identified there at 1112, you know there is a car that pulled up, and you would know if it's consistent with other video outlining that car's movements, even if it couldn't be 100% identified on that particular camera. So again, I'm failing to see how this would be exculpatory if you have the pattern of the vehicle on all these other cameras. But let's continue.
The next issue is the year of the car. Law enforcement works with the FBI to determine the year of the car, and the FBI provides some possibilities after numerous submissions to them, and the court knows this and can read about this. This is going to be in, I believe, D10. That's in D9. And finally, after several submissions, that's when the FBI IML says, I can make a car identification. The issue with that that's not disclosed to the magistrate is that car appears one time on one video and not any of the others that they try to say are the path. It's not, let me see if I can say this right. It's not following a consistent trail where the one camera that can identify the car where it appears again. It appears one time, and then what law enforcement did was they took several videos from all over the area and said, well, it's the same car, and we have an identification. That's not all. The identification was most comfortably from that FBI agent to be a 2011 to 2013 Elantra, and that's what law enforcement relied on. The court has, it is D12, and it's the Be on the Lookout that was issued by Moscow Police Department, where they look for a 2011 to 13 Hyundai Elantra, and that's what they're looking for, and they don't tell the magistrate that's what they're looking for. They mislead the magistrate and let the magistrate believe that they have a clear view of this car making this loop, and that's just not what happened. It's pieced together, and it doesn't make a whole lot of sense.
Okay, again, if you have different video of a white car that is later determined to be a Hyundai Elantra, even if the FBI expert could not clearly see in those videos what year it was, and let's say there was only one video that was clear enough to identify it, in the end, Agent Imel still said it was 2011 to 2016. Who cares if he was more comfortable with 11 to 13? He still gave an expert opinion in the end of 2011 to 2016. That was his expert opinion. Okay, so this is something that should be brought up at trial, not for a Franks hearing, where he can be cross-examined on the stand and state why he expanded it to 2016. To say that they purposely misled Megan Marshall in the affidavit is ridiculous, because the FBI agent did say 2011 to 2016 in the end. That was the bottom line. Even if earlier he thought 2011 to 2013, he still expanded it to 2016. So this is something that should be taken care of at trial, not a Franks hearing. Because again, why would putting in there that originally he thought 2011 to 13, why would that change Megan Marshall's opinion? Because once she found out he changed it to 2016, then it still leads to probable cause with Kohberger. They can't act like he didn't expand it to 2016. And it sounds like Anne wants to try to put that back in the toothpaste tube, and you can't. Once it's out of the tube that he expanded it, you can't put that back in. So let's continue.
Law enforcement in their affidavits talked about this dog barking, and they key some time, and they say this is when something was happening inside this house. We can hear this dog barking, and they use the videotape to get a time off that, the surveillance tape from the neighborhood, the 1112 King. And so they've got this time, but they also have this video, this trail, that they've picked out a time that something probably happened here, and they don't tell the magistrate that this dog that's barking continues on long after the car they're interested in has left the area and then abruptly stops.
Okay, again, why would this be exculpatory? Why would it need to be put into the PCA? I had a Chihuahua, and I also have a cockatoo, and she barks like that Chihuahua, and the Chihuahua would bark incessantly well after somebody left, and my cockatoo still does the same. If the mailman comes, she'll still bark looking out the window for a good 10 to 20 minutes after he leaves. If the DoorDash delivery driver comes, she still barks well after the person leaves. Pets do that. You can't honestly say that because the dog kept barking that means the crime was still taking place. This is a really, really big stretch by Anne. I'm surprised she's not needing Ben Gay for the muscle ache after that one.
Your Honor, the dog was found the next day inside the house in a bedroom with an open door, where the other bedrooms that contained people that died, their bedroom doors were open, and this dog had not tracked any blood around. The dog had no blood on it whatsoever, but it was just sitting in an open room a day later. The magistrate is not informed about that either.
Okay, that's another reach, in my opinion. Now, first of all, was the doors open according to Dylan and like Hunter Johnson when he arrived? Or were the doors open when law enforcement arrived? Because she doesn't clarify. And also, if the dog was in one of those rooms, is it possible the dog had been in a closet? Is it possible that the murderer had moved the dog and then later Hunter Johnson or somebody let him out when they got there? I mean, she's leaving out a lot of context, and I guess I don't see how, again, that would be exculpatory, that the doors were found open and the dog had no blood on him. To me, that brings up some more questions about how, but not who the murderer is. I don't see how that would play into probable cause at all. You just then have to question what took place when the murderer entered the house. So I feel like that's another reach on her part, and not something that a Franks motion would be needed over.
Then the police department goes through maneuvers to tell the magistrate that they did this investigation. They talk about a traffic stop, 2 traffic stops actually, and there's no connector in there. This is where the lack of the IGG becomes really important. If you know about the IGG, you know why that would be built. Otherwise, 2 random traffic stops months ago in pretty populated areas with a lot of college kids really doesn't add up to be an investigation. But those are put in there to try to bolster up this investigation and say it was something that it wasn't.
Wouldn't that be part of an investigation, though? Because if they got the tip from the FBI through the IGG about his name, they could start searching for any criminal violations by Kohberger or any civil violations. Also, if they had already been looking at owners of white Elantras, you would think that they would be running all those Elantras also and finding out if there had been any traffic stops. So to me, that seems like an investigation. That seems like an investigatory tactic. And they also did receive his phone number off of that one traffic body cam. So it sounds to me like an investigation, Anne, but, what do I know? I digress. Let's move on.
Probably the worst part of that is relying on, after the BOLO went out for 2011 to 13 Elantra, then WSU, Washington State University officers find cars. They find one that's registered to Brian Kohberger, parked at the apartments he lived in, but it was a 2015 Elantra, and so they don't really do much with it. But this is placed, that is placed in the affidavit like it was an investigative fact, and it wasn't. It was on the 20th of December when the detective, the lead detective, got a hold of WSU police and found out about that and said, oh, hey, you called this in. He didn't know about that before, but there's no context around that. That's just stacked in there like it creates probable cause when it doesn't. You know that's the case when you look at a couple of our exhibits. One is prior testimony from that same detective. And if you look at the messaging between the detective and the WSU police officer about the timing of that.
Now, I could be all wrong on this, but I believe the FBI was who received that tip from WSU. So Payne was truthful when he said he didn't know until the 20th of December, but I believe the FBI all along had been getting those tips and knew that WSU police had spotted it, and I believe they had been in contact with WSU police. I think that's something that's going to come out. If not, then I'll say, hey, I was wrong. Don't listen to me. But I still believe a lot of those tips were going directly to the FBI and that the FBI was having contact with other authorities in the area. And so that is in the probable cause affidavit because I believe Payne later found out FBI knew about that tip. But let's move on.
So it's based on this false investigation trail, and it's based on statements that are completely out of context from somebody that they interviewed that are incorrect statements when you take the totality of the circumstances together, and statements that this person disclaimed a couple of days later because she wasn't sure what she remembered was real, and give that to the judge. If you add in the missing piece of IGG and what happened with that, and as a judge, you've got law enforcement willing to violate their own policy, and you know that you're not being told the full story about what a witness is saying, and you're being led down this path to say there's a real investigation when there wasn't a real investigation, you don't find probable cause on that.
Okay, this is my thought completely. If you put in the IGG, to me, that would make probable cause even larger. So her saying because they didn't put it in there that's exculpatory and misled the magistrate. I honestly feel like it is inculpatory if they had included the IGG. Because again, they didn't break any laws by not following DOJ policy. It's not against the law. And so if you had put in there that his familial history also was a tip that led to him, that's inculpatory. That's not exculpatory. So at the end of the day, I feel like I said it before, throwing spaghetti at the wall to see what sticks. And that is her job, yes, but it's just exasperating listening to this.
If I find that the IGG was not unconstitutionally obtained, doesn't it just add to the probable cause?
Bingo, Hippler said the same thing I thought when I was listening to her saying all that. He had the exact same thought in his head. Wouldn't that just add to the probable cause?
No.
If it were to have been disclosed, it would have simply created more basis to suspect Kohlberger.
Your Honor, if it had been disclosed, think about how that would read. We used a process to make an identification. This is a new technology. This is called investigative genetic genealogy, and we identified somebody. We did not keep any of our documentation because even though Department of Justice policy says we need to, we decided not to. Even though it says we can't go into certain databases, we really wanted to figure out who this was, so we just ignored that policy altogether. I don't know how a judge could find that credible. You don't even know how that happened. There is a great big question mark about how that happened. To Your Honor's point, you should find it unconstitutional. If you don't find it unconstitutional, it's a separate analysis. I appreciated being able to talk to the witness about that today, but it's a completely separate analysis. You're looking at integrity. You're looking at what a court can rely on to sign off on an affidavit or a search warrant. If an affidavit is presented to a judge and you know that the rules don't matter, that terms of use of a database don't matter, and that you're going to hide what you do, and that doesn't matter either, there's not a lot to rely on.
Because none of that is illegal. Violating their own policy is not illegal. Violating terms of service of a website is not illegal. And in the end, the DNA ended up matching Kohlberger. So it turns out the tip was valid.
If law enforcement came to the magistrate and said, we want to go search this house over here, and they said, we really think there's going to be evidence of a crime in there because we've got this confidential informant, and this confidential informant has provided a lead, but we need to tell you that we don't have real reason to trust this confidential informant because they won't tell us how they know that. They gave us a picture, but they won't tell us where they got it from or when they got it or what means they used. They threw away their camera. They threw away all the metadata. They won't tell us anything about that. And by the way, the confidential informant maybe has some integrity issues. A judge is not going to sign off on that. And then if you say, but to support that, I built this false look at a whole investigation here. I'm going to tell you these other things that I know that I had no idea about before my confidential informant was here. And these things don't add up anyway. There is not, in my view, a judge that's going to find probable cause because somebody got stopped by law enforcement. I think it was a seatbelt ticket months before.
The purpose of the submission of that was simply to identify the car that he drove and the fact it didn't have a license plate on the front.
Exactly. Hippler gets it. That was going towards identification of Kohlberger's car.
Wasn't to suggest it's otherwise connected to the homicide, except to say this is a car of interest, and the defendant was found driving it.
Well, let's talk about that license plate for a second, though, because that's not something you can see from the videos. And that was testimony you heard today. You can't see that from the video that the cops relied on here.
Well, that's interesting. I'd love to hear that testimony. I guess when it comes out after both sides have a chance to redact everything from that closed hearing, it'll be interesting because the affidavit states that the car spotted there at the intersection by the A&W did not have a front license plate. So I really cannot wait to see those videos.
So that bit about the license plate, that's something a little bit extra that happened after we have this IGG stuff. That wasn't known before. There was no video collected from WSU before. There was no communication with the officers at WSU before. So before the identification through IGG.
I'm just not tracking why that matters, but go ahead.
Yes, thank you, Judge Hippler. Neither am I figuring out why that would matter to the magistrate.
It matters because this wasn't a real investigation. These are things that are put in there to make it look like an investigation happened, to say, don't look here at this big glaring thing that's missing, this whole piece about why we identified him. Don't look here. We don't want you to look here because this is ugly, this is dirty, and this isn't real. That's precisely why those things are placed in that PC affidavit like that. So based on that, the first warrant gets issued. It doesn't end there. This warrant is not good. There's too much missing information, false information, and information withheld from the magistrate here. But then the warrants just rely on one another. There are other things to add into later warrants as well. And so I want to go through some of those other things with you. I do want to comment on the affidavits being used by a variety of officers. I understand the collective knowledge doctrine, but that's not what is going on here. You have an affidavit that sometimes Moscow police attribute it to the person that really wrote it, but quite often it's just the name taken off, and who claims to have done the work is whoever signed the bottom of it, and it can't be the same. So it's not quite the same thing, and that matters as well.
Pretty sure what we're reading in Exhibit A, at least from the arrest affidavit, is no one was taking credit for doing all the work. It's pretty specific in there what each person contributed. Like Brett Payne talking about how he consulted with these FBI agents. So again, I don't think Megan Marshall is stupid. I think she understands that several people contributed to those affidavits.
But let's talk about the second warrant. The second warrant is also AT&T. The first one comes in, and an hour later, they say they have all this data analyzed, and they say they now need 6 months worth of phone records for Brian Kohberger's phone. They do acknowledge that his phone wasn't contained within the geofence when they looked at the geofence. But this second warrant is important, and we're going to talk about minutes difference of time. In the first AT&T warrant, in that affidavit, the police officer talks about 2:42 a.m. that WSU cameras, because they start looking at WSU cameras after the IGG identification, they find a white car that they say is an Elantra at 2:42. So they get the phone records, and then it becomes 2:44 that they say Mr. Kohberger's leaving his residence, 2:44 a.m. And the place near Bishop Boulevard where one could turn to go to Moscow at 2:42 is inconsistent with 2:44, but they don't correct that.
Okay, and looking at the probable cause affidavit, they use the term approximately. I don't see anywhere in there where they're stating any of those times as hard and fast. They are stating approximately. So I don't see how that's misleading to the magistrate. Now, I would love to see the cast report. I would love to see the call details where the pings were when he was handed off to each small cell or tower, because then we would know for sure. I guess we can only go by what Anne's saying right now, but I do note that in the probable cause affidavit, it says approximately, at approximately 2:44 a.m. They don't commit to it hard and fast.
They don't correct that. They don't say that vehicle at 2:42 cannot have been the right white Elantra running around that night, because we now know it was at 2:44 a.m. They want to keep that in there because they want the car positioned like it's going to be going to Moscow. And that is really important with the misleading of the magistrate. When you look at 1A, that's the map we looked at earlier today, where there's the whole loop around, but there's a blue line as if pointing the car towards Moscow, and that's not what happened. They then report the phone stops reporting to the network at 2:47 a.m., and that's not right. We submitted their cell experts report that say the phone stops reporting at 2:54 a.m. We submitted 2 affidavits to you from our experts who have worked with the call detail records, and that's just not right.
Okay, so that sounds like there's a difference in maybe the plotting programs that were used between like Cellbrite or Cyrase Tracks. And that's something that I guess would need to be hashed out at trial when you cross-examine these experts, because obviously there is going to be differences in the programs used and differences in opinions based on what you found when you plotted the data. But I am failing to see how it matters what time the phone stopped responding, because that's like an hour before the murders. If you were talking about it stopped responding while he was allegedly in the house, then that's completely different when you're trying to pinpoint the actual time of the murders. But just an hour before, when he's driving around Pullman, I don't see how that 7-minute difference would be exculpatory or inculpatory. I don't see how that would make a difference to the magistrate at all.
Don't get caught up in thinking 7 minutes don't matter here. We're talking about ground that can be covered in a vehicle in a short time. We're talking about 2 towns that are fairly close together. And so the way a car points when they go off the network matters a whole lot in this circumstance. That's not corrected in any of the affidavits.
Okay, sorry if I keep interrupting, but my thoughts, keep going on this. Just because his car was going one direction when it said he went offline, it doesn't mean he couldn't have turned down another street going the opposite direction within that very next second or minute. So for either side to try to claim he was headed somewhere based on that is kind of ridiculous. What we do know is that the car is allegedly seen in Moscow at a certain point that morning, and it doesn't really matter exactly what direction he was going in Pullman when that phone went offline. What matters is where they believe the car later ended up. That's just my thought on that. So I feel like this whole part is another stretch.
That's the part that's really exculpatory to Mr. Kohberger, is what direction, when the phone stops reporting to the network, what direction is the car traveling? And you can know that based on the cell towers, the handoffs from tower to tower as it tracks where a phone's going. The FBI knows how to do this. They chose not to do this. They chose to take a time 7 minutes before it really stopped reporting, and they chose to make a map that showed a direction that phone wasn't traveling in to create a false narrative for the magistrate to rely on to find probable cause. Once the second AT&T warrant comes, then you end up with warrants for Mr. Koberger's arrest. You end up with warrants for DNA samples to be taken, warrants for the search of his apartment, the search of his car, the search of his parents' house. Those are the warrants that are next implied in that. Here, what's added to that set of affidavits is the paragraph that talks about Mr. Koberger's phone using a tower that provides service to 1122 King on a number of occasions. The PC affidavit says 12. Your Honor needs to take a look at D1B and C. That's an email from Nicholas Balance, and he's talking to the detective in Moscow about the dates that he says this thing happens. And then he puts those dates in his cast draft report and in his cast final report, and they don't match up. There are different dates on those, different times on those.
Wait, so is she saying Agent Balance changed those dates and times from the draft to the final cast report? Because I would love to see that. And if he did change those dates and times, then that tells me that they received more information from AT&T in the meantime, from that draft to the final. But the thing is, the probable cause affidavits were done before the final cast would be done. So I don't see how you could say that is Frank's material when those affidavits were done based on the knowledge they had at the time. And that is not like reckless or intentionally, misleading or lying or anything. You're using the information you had from the FBI at the time.
But the really big deal about that is that it's misleading when you say the cell tower that also services this particular location. Moscow has, I think, 2 cell towers that service the town. Those cover places that one shops, places that one eats, places that one gets gas in Moscow. From the records, you can see handoffs, and so you know where a vehicle is going. You can know whether it's stationary or not. You can know whether it's parked, looking at a particular place or not.
Okay, but here's the thing. Moscow has 3 FCC registered towers, and then they have several towers that are shorter and small cells. So her saying that there's 2 that service the whole town is very misleading if she wants to talk about misleading. And yes, they would know where the phone got handoff to each cell system. But also, they know exactly where he went. And I'm sure we're going to find that out when we get to see the full cast report at trial.
Based on those records, we also provided the records just so the court would know there's a volume of records. I don't expect the court to decipher those records. But based on those records, they absolutely knew that Mr. Koberger wasn't around that residence, wasn't parked near the residence, didn't stop and have his phone in a stationary position at that residence. They absolutely knew that that's not what was happening, but they put it in there to make a connection that didn't exist. They put it in there so that the judge would think that this was the right person, and they shouldn't have done that. They knew that was incorrect.
Well, actually, if you look at the probable cause affidavit, they say that they reviewed that information to see if there was stalking. If you notice in the affidavit, it never says that he was stalking them. They reviewed that information just to see if that took place.
They also changed that quite a bit, performed a drive testing, and so there were other bits of data that kept coming in so that they would know that was untrue.
Okay, me interrupting again, but she said they changed that data. They performed drive testing. From what I'm understanding, is the drive testing was completed well after Koberger was arrested. So again, the information on the warrants would have been what was known at the time from the FBI. If those things changed months later, that's not the same as intentionally misleading the magistrate, because they were going with the information they had in December of 2022.
Now, for a magistrate to be relying, remember, on somebody who's a witness, somebody who's been interviewed 4 or 5 times, and continually says something that's absolutely impossible, has memory problems, and the judge never knows that, and we'll keep the IGG identification off to the side, but then you have this false narrative that looks like stalking, that looks like following, and it's not true. That is extremely damaging. It's very misleading. It's an outright lie.
Okay, Anne, where's the lie? Because in the affidavit, it does not say he was stalking. It said they reviewed that info to see if there was any stalking. It doesn't say he stalked them. So where is the lie that you claim?
To the magistrate, when you omit that kind of information, when you take that context out, you might as well say stalking, because that's what you're trying to say, and you know that's not true. This court can rely on our proffer in D1B and in the CAST draft report and in the CAST final report, because those dates change. The court can rely on the evidence that will be produced at a hearing from defense experts that will talk about the handoffs, the patterns of handoffs, and how misleading that paragraph was to the magistrate. The real story is exculpatory to Mr. Koberger. He was not stationary around that house. He was never at that house. He did go to Moscow. He did drive around, but he wasn't over there. And the phone records absolutely show that. We'll move forward to the set of warrants that come a little bit later in February, March, April. I'm talking about Amazon, Google, Apple, those kinds of warrants that come later. Here's what is left out of all of those warrants. The fact that Mr. Koberger gets arrested, his apartment gets searched, his car gets searched, his car gets searched again, and his car gets searched again, and there's absolutely no connection between him and anybody from 1122 King. And what I mean by that is that there's no blood in his car. There's no he wasn't connected to that house, to the people in the house. Your Honor, I'm
Maybe I mistake me thinking of a different date for the AT&T. I thought, not the cell tower stuff. Are you still talking about the cell tower stuff?
No, I mean, that stuff applies to every single warrant we have, because that was
I
early.
thought you transitioned to warrants that were obtained after the arrest.
I did.
Yeah, and by the time of the arrest, they had a direct DNA connection.
Your Honor, what I'm talking about,
Some other evidence that the defense can claim in cross-examination or their own case is exculpatory, but isn't the DNA connection in and of itself probable cause to support any of it from there?
Your Honor, the DNA I'm talking about is the lack of DNA in Mr. Koberger's car and the lack of DNA in his apartment, the lack of connection to the individuals.
What is that? Even if disclosed, preclude a finding of probable cause when there's a DNA match between the DNA in the sheath and Mr. Koberger. Isn't that probable cause every day and twice on Sunday?
Thank you, Judge Hippler. Yes, every day and twice on Sunday. And remember, he had 6 weeks, basically, from the crime to when he was arrested. Do you really think you were going to find anything in the car? And we've seen from other murders, Christopher Porco, for example, that not one shred of blood or DNA is found in a vehicle when somebody has that much time to clean. But also, as Judge Hippler stated, it doesn't really matter what was found in the car or not was found as far as the warrants, because there was already DNA left at the crime scene that matched Kohberger.
Not in this context. Not in this context because of the IGG work. Because I mean, that's the ultimate question that will be before a jury. What does that mean, right? What does a knife sheath at a scene mean? That's going to be the ultimate question.
Killed by a knife, it probably means a lot.
It might mean a lot.
Probable cause is not a proof beyond a reasonable doubt standard. There's probable cause to think that this person might have done it. And I'm not sure how that direct DNA connection to a sheath found on or near one of the victims doesn't close the book on anything on probable cause after that.
Say it again for those in the back, Judge Hippler. Say it again. The standard for an arrest is probable cause. The standard for warrant is probable cause. That's not trial where it's proof beyond a reasonable doubt. She's acting like it needed proof beyond a reasonable doubt and not just probable cause. And these warrants only needed probable cause. And once there was the DNA match to Kohberger, that solidified for all the rest of those warrants.
Well, I think it doesn't close the door on probable cause. I think when you know the other factual information that the magistrate should have known, I think that there's a lot of pause even at a probable cause level, Judge. This was information withheld from the magistrate, and I'm talking about, let's just go with the car.
I understand the lack of evidence of DNA material or other victim-related material in the car and in his apartment as asserted, but I'm not sure how that precludes probable cause when there's a direct DNA match. There's plenty of reasons that might be the case. When a magistrate's looking at this, they have a direct DNA match to a person from a object likely associated with a murder weapon. I've not yet met a magistrate would not find that probable cause.
Exactly. Judge Hippler is spitting facts. It doesn't matter what else might have been omitted or added to that PCA. Once there was that DNA match for those subsequent warrants, that establishes probable cause.
If the magistrate had the other facts, I think the magistrate would have some serious concerns and would not find probable cause. Your Honor, the vehicle, and I know the court knows what I'm going to say, there's not DNA in that vehicle that was brought out from a crime scene. This absolutely matters, Your Honor. If you want to go to the state's theory, right, with their videos that they've talked about, that they told the magistrate about, that this is the video, this is what matters, it parks at this certain time, it leaves at this certain time. If you want to go to that, there's about 13 minutes of time, right? 13 minutes between the last time you see the car and the next time you see the car on the video. And if you end up with a car that's searched, and I mean searched and taken apart, the brake is taken apart, the gear shift is taken apart, the key fob is checked. There's no blood on any of that, none. The steering wheel, there's some kind of spray all over the interior of the car to check for it. There's no blood. I think that there's context that the magistrate should have known that's absolutely exculpatory to Mr. Kohberger, and it matters a whole lot.
That's not necessarily exculpatory. I had just mentioned Christopher Porco. Robert Tellis's car also had no evidence matching him to his victim. But it doesn't mean he didn't kill the person. He just was able to take precautions ahead of time and then also clean the car afterwards. So just because you don't find anything in it doesn't mean it's exculpatory.
I'm not saying it's not potentially exculpatory. I'm just saying I'm not sure how knowing that in light of a positive DNA connection would trump, would cause any magistrate to say, well, okay, I guess there's no probable cause here because you couldn't find other connection to forensic evidence, when there are other things in the affidavit that, or affidavits at that point, that could explain that, including the use of covering clothing and covering gloves and all that could be put into a bag real quick on the way out that was in one of the affidavits.
Now that's interesting. Would love to know which affidavit talked about covering clothing that could be put into a bag, because that's obviously not in the arrest affidavit. So that's a new tidbit. And remember, it was rumored that he had been wearing coveralls that were easy to take off. And there was even the rumors about the receipt for Dickies coveralls. Now, I have been very skeptical on all of that because until I see something that actually proves it, I'm taking it as just a rumor. However, the judge just left a big nugget there that one of the affidavits talked about being able to take things off and put it in a bag. A lot to ponder there.
I guess, and I don't intend to argue with you about it. I mean, I understand your other arguments, but when you get to once they have the actual DNA, evidentiary DNA, it seems to me that it's an uphill battle to say there's not probable cause at that point.
Well, Your Honor should never get to that question, but I'm going to answer it for you. But you should never get to that question because you should have already found that AT&T 1 and AT&T 2 were terrible, and there's no probable cause for those, and they just build on each other. So you should find that the very first one lacked probable cause, and then everything else does as well. But let me answer your question there. If the magistrate judge had been told there's unknown male B in blood in the house attached to the handrail, that might have made more of a difference to her.
Question: which handrail? The handrail on the stairs from the first floor to the second floor, or the second floor to the third floor? Because it would make a difference, especially if it's considered to be from a putative perpetrator or not. I've already done a video talking about when DNA can be considered from a perpetrator or not, and when it's eligible for running through CODIS. And it would be really important to know which handrail and also the movements of the perpetrator through the house as to whether that blood on a handrail would even be from a perpetrator.
Maybe a sheath that can be carried to the house and blood in the house that's not the same, maybe that matters. And then maybe the car being completely empty of any blood DNA connection, maybe that matters a little bit more. Maybe
Well, I'm just not sure why it matters for probable cause, but I think we're talking over each other, so I'll let you just go on.
I don't think probable cause is in a vacuum. I think probable cause isn't one thing. I hope it's not one thing. I hope there has to be a little bit more than one thing, especially when you've got another thing that's the same as the one thing.
Well, I said I wouldn't do this, but I'm going to do it anyway because you brought up blood DNA of an unknown individual that was found, I think, on the handrail.
Yes.
Doesn't that necessarily not exclude Mr. Koberg? What it may do is suggest there might be a potential other person in addition involved if you assume that that blood was related to the victims and not some earlier event in the house.
Exactly. Thank you, Judge. How do we know it was fresh? When it was from? They had a party there on that Friday night. Could have happened then. Could have been old, dried blood that Anna's just trying to use to muddy the waters. Also, like Hippler's saying, how would that necessarily exclude Koberger, it could just mean maybe he had a co-perpetrator. So just the presence of another blood in the house, it does not necessarily exclude one suspect.
If, what the court is saying is exactly why the magistrate needed to know that. Is there another explanation here? I've got this sheath, but there are all these other things that if I know about them, matter. What's the other explanation? What's going on with this investigation? What's happening here? That's exactly the point, Your Honor. What other explanation is there? The magistrate wasn't given a chance to ask that. She wasn't given a chance to ask that when she wasn't told about unknown male B, blood on the handrail. She wasn't given a chance to ask about that when she wasn't told about unknown male D, blood on a glove right outside the residence.
Now, if somebody has proof to the otherwise, I had understood that there was the glove that Chris McDonough guy found. But there was also another glove that was found as well that believed to have come from one of the investigators that had accidentally dropped it short of the garbage can. And both of those were found days later and outside of the search perimeter, like after they had already searched. So my understanding is neither one of those gloves or anything in those gloves would be related to the case. But if it comes out at trial that they were, then I will eat my words and say, hey, I was wrong. But, and also I've heard people saying, well, a bloody glove. Well, there's nothing that says it was a bloody glove. Okay, it could have been a small trace amount of blood, maybe somebody that nicked a finger or had a hangnail that started bleeding, their cat had scratched them, etc., etc. People are jumping to conclusions immediately that glove or the gloves outside must be related, and we actually don't know that. Also, Anne is saying, well, don't you think if the magistrate knew these things that she could say, well, what's the explanation for this? Maybe this has a different explanation. Well, isn't that all the more reason to issue the search warrants? So you can determine what the explanation is behind things. So if you have a sheath there and you believe that sheath, based on the IgG tip, had blood on it, or excuse me, DNA on it from Brian Koberger, and you're trying to find out the explanation for how his DNA ended up on there, wouldn't search warrants be helpful in being able to determine whether he was involved or not, what his receipts show, what his search history on things show, what his cell phone records show? I mean, that's all called investigating. And I know she loves to sit here and say this was a fake investigation, but it sounds to me like these warrants were an actual investigation.
She wasn't given a chance to ask any of those questions. She didn't know that Brian's car, and the court's question, good question, what does that mean? Could it mean there's more than one person? The answer to that is, or it could mean it's not Brian because his car's got nothing in it and there were only 13 minutes to do this.
As far as the 13 minutes, Nicholas Mew stabbed, 5 young people in less than 48 seconds. Okay, you look at the Australian shopping mall guy, how many people he stabbed just within a few minutes. 13 minutes is more than enough time for a perpetrator to stab 4 people to death.
The magistrate didn't get to know that.
In fact, his DNA is still on the knife sheath, though. That's the problem, counsel, for probable cause purposes.
If that's the only thing she's told, I can see why she'd find probable cause. It's these other things that are withheld that create a context around it. I think the purpose of Frank's is to ask this very question, and this is a question. What do we want to do with our criminal justice system? Do we want to have one thing with no context around it when there's this other context that really matters?
Applying the Frank standard, which is, even if you add that stuff, does that take away probable cause, counsel? And my problem is, once you have a direct DNA tie to the defendant, for purposes of probable cause, this isn't for purposes of conviction, for purposes of probable cause, you have not explained to me why a reasonable magistrate, let alone any magistrate, wouldn't find probable cause there, even if they knew all those other facts.
Yep, say it again, Judge Hippler, say it again, because there's some people that still aren't getting that. There's a difference between probable cause and beyond a reasonable doubt.
As to Mr. Kohberger, now, there may be, as you say, other people that creates concern or issues about that need to be investigated further, but I'm not sure that that diminishes the probable cause as to Mr. Kohberger if his DNA is found on a knife sheath found on or near the victim who was stabbed with said alleged knife that would have been in said alleged sheath.
I think the most prominent question is, how did that sheath get there? And I think when you ask that question, I think you can have DNA on an object at a scene when you know about all of these other things and you don't find probable cause, because there are more questions than there are answers. And all of a sudden, this one thing doesn't look as big. It doesn't look as everything pointing to it when you have the context around it. The magistrate didn't have to have every detail of the case, but knowing how many attempts to find a DNA connection there were, and it didn't exist in Brian's car, in Brian's apartment, that there's no other DNA in there other than an unknown male B that we know of for sure, an unknown male D outside. There is a lot of context there, and all of a sudden this one thing, the question of how is that there, is the question that the magistrate should have had.
If I'm not mistaken, wouldn't those search warrants then help to determine how the sheath ended up there? If you can investigate into the alleged suspect, to the person that you're looking into, those warrants would help be able to determine how that sheath came to be there. So why would Megan Marshall not approve those warrants, even if all that other information had been given to her?
And then we come to all of the other things that we've talked about. We've come to what we relied on. One of the witnesses saying things that absolutely couldn't be true. One of the things that the witness who said these things that couldn't be true also admitted she didn't really know anything. You can't rely on that anymore, so you take that out. You know the identification to this sheath that maybe seems like it would be really good. You don't really even know how that happened, and you don't know how it got there. This isn't like DNA in blood on the wall from Mr. Kohberger. That's not there. That doesn't exist in this scene. You're talking about an item that the question of how should be, especially when you know about the other male DNA in the house, and especially when you know about the lack of DNA connections. There's also no connection between the people in the house and Mr. Kohberger based on their cell phones, based on social media accounts. There's just no connection.
Connection has never been needed to find probable cause. It actually has never even been needed to convict someone. You look back at a lot of murderers, they didn't have a connection to their victims before they killed them. So, to me, that argument is just very weak.
The magistrate wasn't aware of all of those factors when she was being asked to decide on probable cause. I don't think criminal justice means one piece of evidence out of the context of everything else is all you need. Context matters a whole lot.
Well, you're not suggesting the magistrate was told that there was DNA evidence found in Mr. Kohberger's car or in his apartment. The lack of inclusion also can be viewed as the implied of they're obviously not telling me they found this when they would have if they did.
I'm not 100% sure I followed. I'm not sure. Are you asking me why I think that's important as far as the Frank's purposes?
Well, for Frank's purposes, you are implying, I think necessarily, that the police intentionally didn't tell the magistrate that they didn't find the lack of evidence in other places, the apartment, the car, et cetera, right?
Yes, that's right.
They didn't tell the magistrate that there was evidence. This is a omission.
This is one of the omissions, yes. Yes, we have false statements and we have omissions both. It's not one thing in this case.
I was understanding completely.
Yeah, thank you for that. I wasn't following the question the court was asking. I think the other thing, I think I covered all on my proffer, Your Honor. Thank you.
Okay, I didn't think that went well for Anne at all. I didn't feel the IGG argument earlier in the day went well for her, and I didn't think these Frank's arguments went well for her. Now, we will see. Judge Hippler still hasn't decided yet on whether he's going to allow a Frank's hearing. He may go ahead and decide to do one. But based on how he was questioning her, especially on probable cause and how he kept reminding that probable cause is not the same standard at a trial, beyond reasonable doubt, I don't get the impression he thinks there were any thing worthy of a Frank's hearing. But again, we shall see. I've maintained I don't believe he will grant one, but I could be very wrong. So now my next video is going to be the state's rebuttal, and that's with Ashley Jennings. And I will just tell you right now, while I feel what she was trying to get across was correct, she is a terrible courtroom presenter. So I will just get that out of the way already. So look forward to my next video.